welcome to the fourth session of the National Law Conference sessions here. This session, of course, ladies and gentlemen, is on criminal justice. And our topic of discussion, progressive developments and significant transformation in the criminal justice system in Sri Lanka, focusing on economic and social aspects. Ladies and gentlemen, of course, as you quite well know, we are really stripped for time today. And the eminent panelists, of course, ladies and gentlemen, are well-known legal luminaries in Sri Lanka, and their reputation, of course, precedes them, ladies and gentlemen, and therefore I will be going for a short introduction. Of course, all of their credentials, ladies and gentlemen, are available on the pamphlet that has been distributed already amongst all the attendees. First, ladies and gentlemen, our first panelist on the criminal justice session is Honorable Justice Buenakalu Viharaya, President's Counsel, former Justice of the Supreme Court. We've also got with us Mr. Mohan Veerakon, President's Counsel. Thank you very much, sirs, for accepting our invitation and attending this session as panelists. We've also got with us President's Counsel Salia Pires. Thank you very much, sir, for accepting this invitation. We've also got President's Counsel Sarath Jayamana. And of course, our very able moderator for this session, Mr. Asela Serasinghe, attorney at law. Without further ado, I hand over the proceedings to Mr. Asela Serasinghe. Over to you.
Thank you, Charlotte. It's a post-lunch session. We have gone a bit above time, but it's going to be a very interesting session, ladies and gentlemen, because anything to do with criminal law is generally very interesting. And the theme for today's session is progressive developments and significant transformations in the criminal justice system in Sri Lanka, focusing on the economic and social aspects. When we talk about the economic and social aspects, in this discussion, we thought of sharing some knowledge from our eminent panelists about some very important topics. We will be touching upon the anti-money laundering framework, the proceeds of crime framework in our country. Also, the question that most criminal practitioners often are encountered with regard to investigations, fair, impartial, comprehensive investigations. And also tied up with that is issues concerning bail. So, as we touch on these topics, we will move in a question and answer format so that it will be interesting to our listeners and we can talk about certain specific issues also later on. So let me, without further ado, start with our first question. Justice Alvihare, President's Counsel. Sir, now when we talk about the anti-money laundering framework of Sri Lanka, there is a lot to talk about, sir, but for the benefit of our audience, sir, would you be able to explain in that very simple way that you often explain complicated things, the general framework with regard to the anti-money laundering law that we have in our country?
Thank you, Asela, for the introduction. Before I answer Asela's question, I want to convey something to the legal fraternity who are here today. The reason why I chose this topic is, in time to come, there will be more and more cases coming up in high courts in relation to this area. It has just started, right? That is not the important factor that I want to mention. There'll be huge amount of monies involved, and your services will be required, right? So there is a big cake. Don't allow Mr. Salia Pires, Mr. Veerakon, and Mr. Jayamana to eat the cake. Share it. You have to share it. So if you gain knowledge, there are a lot of money involved. That is the reason why I chose this topic. Okay, right. Okay, having said that, I will approach this question you asked Asela in a slightly different way. You asked me to explain what money laundering regime is. No, I think what I want to say is, over time, the criminal jurisprudence has developed world over, and legal regimes relating to forfeiture of criminally tainted assets. Forfeiture of criminally tainted assets have emerged world over. right? And then other factor that I want to mention is this legal regime is universal, right? Meaning no country can be without it because of the pressure by the international community, right? So what I'm trying to say is the legal regime cannot be localized, right? All countries have to legislate and need to adhere to set of international norms in creating legal regimes relating to forfeiture. So that is something that you have to keep in mind. So if we have a set of laws, those set of laws we have not enacted it the way we want. We have enacted it the way the international community has the guidelines and the criteria set by the international community, right? That's something that you have to keep in mind. Okay, quickly we will look at what are the main forfeiture laws we have in the country at this point. We have the Prevention of Money Laundering Act, which creates the offense of money laundering. Then we have the Convention on Suppression of Financing of Terrorism Act. Then thirdly, we have the Proceeds of Crime Act. So these are the three main acts dealing with forfeiture of assets. Now, without encroaching into area Mr. Jayaman is going to deal, I will try to see how these three enactments deal with forfeiture of criminally tainted assets. If you take the Money Laundering Act, what it does is it criminalizes money laundering. Okay, Money Laundering Act criminalizes money laundering. So you have to understand what offense of money laundering is. Then, if you look at the other enactment, I said suppression of terrorist financing. It basically prohibits financing of terrorism, right? Financing of terrorism. So these are remember, offense of money laundering and offense of terrorist financing are conviction based offenses. In other words, if the court wants to forfeit assets for money laundering or terrorist financing, necessarily there has to be a conviction, right? What does that mean? That means you have to prove those offenses beyond reasonable doubt. Then only the forfeiture aspect kicks in. But if you look at the Proceeds of Crime Act, it is slightly different. I'm not going to encroach into this, but just to introduce this forfeiture regime, I will say that and I will stop at that point. Is non-conviction based forfeiture regime, right? Non-conviction based forfeiture regime. So if that is the case, if there is no conviction, what should be the standard of proof? On a balance of probability, right? So this distinction you have to keep in mind. The prevention of money laundering and terrorist financing are conviction based, and proceeds of crime, it's a non-conviction based forfeiture, right? Now I will very briefly, right, come to the question Asela asked: what is the money laundering regime? What's the money laundering act in Sri Lanka? Right. Before I explain what the money laundering offense is, I want to tell you what money laundering is in the first place. Right. The reason why I'm saying this is because I can't explain the offense of money laundering without telling you what money laundering is in the first place. Remember, right, the reason why I want to approach it this way is because money laundering and the offense of money laundering, I'm again repeating that, money laundering and offense of money laundering are two different things, right? So if I don't explain to you what money laundering is, then straight away go to the offense of money laundering, you might get confused when you start reading literature at a later point of time, right? Remember, forget about the offense of money laundering. I will briefly tell you what money laundering is. Money laundering is a process. Money laundering is a process, right? What is this process? Money laundering is the process of making illegally obtained money, right? It's a process making illegally obtained money appear legitimate, right? Appear legitimate, or they are trying to give a clean appearance uh, to illegally earn money. I will give you a simple example. The question is, why do people have to go through this process to clean money, right? You take a drug dealer. You take a drug dealer. So what happens? The drug dealer sells consignment of drugs and earn huge amount of money. If he goes to the bank and straight away try to bank it, it would arouse suspicious. How did this man get this money suddenly? And it can trigger a criminal investigation and check his background. So because of that, people don't want to do that. So they try to give it a cleaner appearance. I will give you a very simple example of this process. Right. If I am a drug dealer, when I sell money and I collect profits or I get profits, what I do is I will not straight away bank it directly into the bank. What I will do is I will open a business, right? So say I'm going to open a Kotu business, right? And then I'll open a chain of Kotu places, and I know we have Doctor Kotu, all those things. I will call it judicial Kotu. No one is going to eat that. Okay, right? Okay, right? Then what I will do is I'm not interested in running the Kotu business, but I will bank money through these Kottu selling agents, saying that these are the profits I earn through by selling Kottu. Then no one will feel suspicious about it. I gave you a very simple example of money laundering, but it is much, much more complicated than that, because you find professional money launderers who help these people to launder money, right? If you are interested, you can read this book. This is called The Laundry Man, right? Why I brought it here is he was a lawyer, right? Right. I will read this back cover. It says, meet Ken Rijok. He's the lawyer, twice decorated Vietnam veteran, high flying lawyer, and one of the world's biggest money launderers, right? So what happened was he got convicted and he went to jail. He got a 20-year jail term, this lawyer. So while in jail, he wrote this book, right? While in jail, he wrote this book. Ultimately, what happened was he entered into a plea bargaining with the FBI and said, "I will help you to locate all the money launderers," and his sentence was reduced. So that's a different story. So what I was saying is that money laundering is a very complicated process. I explained to you what money laundering is. Now, basically, if I tell you in one simple sentence what money laundering is, it is a case of disguising the true nature of the criminal appearance of money and trying to give it a legitimate look. Okay, that is the money laundering process. Right. Now, I will, in trying to finish this in 2 lines, I will explain to you the offense of money laundering. Section 3 of the Prevention of uh, Money Laundering Act defines what the offense of money laundering is. There are 3 elements to it. One is engaging in a transaction that involves proceeds of crime, right? Engaging in a transaction that involves proceeds of crime. Second one is acquiring, using, or possessing property derived from illegal activities. If you look at these 2 limbs, it has nothing to do with the process I told you earlier. Simply, if I sell drugs and illegal money comes into my possession, I have committed the offense of money laundering. Why? Because one limb of this is possessing property derived from illegal activity. I sold drugs, which is an illegal activity, and I received money, and I am in possession of that. And then because of the definition, I am guilty of what? Money laundering. But that is why I said the process of money laundering and the offense, there is a mismatch. So that mismatch you have to understand. Basically, that is why I explained the process of money laundering and to tell you there is a distinction between the two. The second one is acquiring, using, or possessing property derived from illegal activity. The third limb is concealing or disguising the true nature, source, location, or disposition or ownership of property obtained through criminal means. So it is only the third limb of the offense of money laundering really speaks of the process of money laundering I explained to you little while ago. Okay. So basically, I'm not going to go beyond this point. I hope my explanation will enlighten you on this aspect. Thank you.
Thank you, sir. I think there's a lot to talk about, but sir. Now, we already had the anti-money laundering legal framework, but there was a need felt for a proceeds of crime law as well. Now, Mr. Sarath Jayabhan, President's Council, has been involved in this issue of uh, bribery, corruption, anti-money laundering, and also the proceeds of crime framework. Sir, will you be able to explain to us what was the need for a Proceeds of Crime Act and what does it seek to achieve in our country?
Thank you, Asela. I will take a very simple example, and lawyers are very familiar with this. We'll take a simple case of a robbery of a van. Two perpetrators come in a motor bicycle, show a gun, and rob the van. And they go away with the van. Later, police recover the van and the bicycle. What will happen to this van and the bicycle? Van and the bicycle will be used as evidence. And van and the bicycle will be in the custody of the police officer. What will happen to the van and the bicycle at the end of the trial? You know, under section 425 of the Code of Criminal Procedure, what do? Very likely, van will be given to the person from whom it was recovered. The owner will get the van. The cycle, the perpetrator came, it won't be given to them. Very likely, it will be forfeited. The van and the bicycle are these are the proceeds of a crime? No. Van is the subject matter. Van is the matter on which the offense was committed. The bicycle is the weapon. Bicycle was used to commit the offense. So these two properties are not certainly proceeds of a crime. We'll take another example. Take, for example, drug case. The accused is caught with drugs. He'll be charged for possession or for trafficking. Is it a proceed of a crime? Certainly not. Certainly not. What happened? If you sell the drugs and earn some money, then go and deposit somewhere or keep it for yourself, then that money becomes proceeds for crime. At the end of the drug case, if you possess, what will happen? Drug will be forfeited. Now, what will happen after selling the drugs? If you possess the money, can you deal with that money under the Criminal Procedure Code? No. That is why Justice Bune Kalvihara said, with regard to the money that was recovered from a proceed, you have to have a money laundering law. Then, when the money laundering law is there, the government came out with a new piece of legislation, proceed of a crime. What do you mean by a proceed of crime? Like the money earned through the drugs, there are other offenses. For example, offense of corruption. What is the corruption? A public servant gives a tender or pass the tender to a wrong applicant. Why? He decides to give the tender to one party against all these procedures. What he does with criminal intention. What is the intention? By taking this decision, he wants to see there will be undue benefit to another party, undue loss to another party, or there's a loss to the government. The moment that happens, what happened? Offense of corruption is committed. But then what happened? The proceed of the corruption, we do not know. The public servant may have deposited that money that comes to him indirectly. Where? In Australia, in Seychelles, in Uganda, some other country, through various means, he may have deposited this money. If he has deposited this money, it may come under money laundering also. In Money Laundering Act, you can go for proceeds of crime for specific offenses. Under the proceeds of crime law, there are so many offenses. For any offense, proceeds of crime can be dealt with. That is the proceeds of crime law. Now, what is the purpose of the proceeds of crime law? Ultimately, purpose of the proceeds of crime law is to finally forfeit this procedure. Why finally forfeit this procedure? Because normally when you charge a person for money laundering, you go after the person who commit the offense of money laundering. But in a case of proceeds of crime, you don't need to prove that he has committed the offense of corruption. You don't need to prove. If you can prove, that is fine. Even if you prove the offense of corruption or not, you can separately target the property. You are prosecuting the property. Why? When the property is seized and forfeited to the government, what will happen? Those people who commit those crimes will not be encouraged to commit any more crimes in the future. In a proceeds of crime law, you are targeting only the proceed. That is called non-connection based forfeiture. When you know there is no purpose involved in drug trafficking, there is no purpose involved in corruption. Why? Even if I am in jail, what will happen? My money will be there. But if the property is seized and forfeited, what will happen? There is no gain for me. I will give it up. In the traditional criminal justice system, we target the offender. But in this novel concept of proceeds of crime, we mainly target the proceed and forfeit the proceed. When you forfeit the proceed like that, there will be impact on innocent persons. There will be innocent persons' property will be forfeited. You can't straight away forfeit the procedure. Before the forfeiture, you have to seize the property. You have to issue to the bank not to do anything with this property, seal it, and preservation orders, restraining orders can be given. So those things will come at the second stage. So basically, proceeds of crime is targeted at the proceeds, not the offender. But if you can try the offender for committing the main offense, we can try. You don't need a conviction to basically forfeit. Under the criminal procedure code, you have to have a conviction. And even under money laundering, you have to have a conviction. But under proceeds of crime, no, we don't need a conviction. We are targeting the proceeds. So we'll come discuss details at the second stage.
Now, thinking about the anti-money laundering law and the proceeds of crime law, we can see that there is a lot of power on the hands of investigators. As criminal lawyers, we know in any case, investigators, whether it be the police department or the bribery commission, they have a lot of powers which affect the citizens of the country. And particularly when we talk about proceeds of crime and anti money laundering laws, there is a question of private property also may be involved, because bank accounts of private individuals can be frozen. It could be other movable properties, vehicles, maybe immovable properties, lands, and so on and so forth. Now, when we think about all of these things, we can see how important it is for the criminal investigators to be impartial on one hand, and also to conduct criminal investigations in a thorough and comprehensive manner. Otherwise, it may result in various allegations of bias, partiality, and also incompetence. So, I want to uh, ask Mr. Salia Piri's President's Council on how we can ensure that criminal investigators can conduct themselves in such a manner so that they will do fair, impartial, and comprehensive criminal investigations.
Yosela. I'd like to start with this part of a judgment of Justice Mark Fernando in Victor Ivan versus Sarathen Silva, Attorney General, 1998, 1 SLR 348, page 349. A citizen is entitled to a proper investigation, one which is fair, competent, timely, and appropriate. For criminal complaint, whether it be by him or against him. The criminal law exists for the protection of his rights, of person, property, and reputation, and lack of a due investigation will deprive him of the protection of the law. So I think the biggest obstacle where we have for a fair trial, uh, the right of a fair trial is enshrined in the Constitution. Justice Mark Fernando in Vijaypala versus the Attorney General has said that the right to a fair trial not only involves the prosecution, but the courts itself are bound by Article 13.3 of the Constitution. Now, this is something very often, sometimes when we go into court, judges say, oh, fundamental rights is something for the Supreme Court. And criminal courts, some judges of the criminal courts don't realize that fair trial, that they too are bound by the provisions of fair trial. And they ought to give a fair trial. But actually, the fair trial does not start at the trial itself. That the very root of a fair trial is at the stage of investigation. And that is, as I see it, there are several obstacles to fair investigation. One big obstacle is that by training the criminal investigators, whether it be the police, the bribery commission, they investigate in order to prosecute a person. So very often there are people who the police do not want to investigate what the version of the suspect. I think, Aseli, you must have come across so many instances. So I'll just give you an illustration. There was a matter down south in a court. 2 people were charged for an offense. The victim's hand had been severed. The second suspect took up the position that he was never there and that he was falsely implicated. And he said he was elsewhere, about 10 kilometers away. He was at he was elsewhere that night. There were witnesses who were willing to confirm that he was there with them. But the police were not willing to record the statements. The police were not willing to take the telephone records. If you track the tower details, it would have clearly established that he was elsewhere. But until about 1.5 months went, he was kept in remand, and the police were not willing to investigate until further representations were made, and until the witnesses themselves went to the police station and insisted that their statements be recorded. So, right across all criminal investigations, one big problem is that. And part of it is also, if those of you who have read Kumaraswamy, you will that investigators, they get this what is called the taste of the chase. That when you are pursuing a crime, you somehow want a victim. You want an accused, you want a suspect. You somehow want to arrest a suspect. Sometimes whether that suspect is the actual suspect or not, guilty party or not, still you want to pursue. So that is one major obstacle we have. I think that is where the police and the institutions, specialized institutions like the Bribery Commission, ought to have an open mind. So this lack of an open mind in investigators is one big obstacle. The second big obstacle, as I see it, is that certain judicial officers do not have an open mind. Uh, at, right at the beginning, in the magistrates' court, I have heard magistrates saying right from the beginning, presuming that the suspect is guilty and proceeding from there. Even with on the question of bail, recently I came across a matter where when the police consented to bail, the honorable magistrate still refused on the basis that the offense was a serious offense. So the question is here, so I think it is also important for judicial officers, especially magistrates, to have an open mind. Certainly there are magistrates who have an open mind, but there are others who do not function with an open mind. And that is an obstacle. The third obstacle, as I see it, is in relation to cases other than bribery. 20 years ago or 30 years ago, we found the Attorney General's department being more proactive. And there was a certain degree of protection which suspects had. If there were police excesses, you could go to the Attorney General's department and the Attorney General would be willing to intervene in when representations were made. I'm not saying that does not happen today, but I think the frequency of that willingness to intervene where an injustice occurs is much less. And there I do feel, and I have shared this with the senior officer of the AG's department also, I feel there is a reluctance on the part of State Council to take decisions. And everything, they wait for the supervising officer's permission. And that is a problem where fair investigations are concerned. The fourth obstacle we must concede to a fair trial and a fair investigation is that lawyers, defense counsel in the magistrates' court do not realize that they play a very important role right at the start. Their function is not only just to go and get bail, but they perform that. They are the equivalent in medicine, the equivalent to first responders. When a client comes to you, he's being arrested, he's going to be produced. What you do at this stage will have a huge impact on the trial, which might be 5-10 years later. And so the steps which defense counsel take right at the beginning, whether it be when a suspect informs that he has been subject to torture, that he has been assaulted, or his version. So in drugs cases, we have this sometimes. There are clients who say, they were not arrested the way the police said they were arrested. They say there was CCTV which will establish their position. But if you don't take up that position immediately, by the time the trial starts, there is no purpose. You will not be able to get the CCTV footage. So there are many things that defense counsel too can do at in the stage of the magistrates' court. And that is where I think perhaps we should also look at our own training, whether young lawyers who just pass out should also be given that training to look at those early aspects of investigation and perhaps to make applications before the honorable magistrates for orders. Because as I see it, Section 124 of the Criminal Procedure Code ought to cover, the court can make certain orders related to investigation. Certain judges, certain magistrates do take out the position that is not only for the prosecution, but that the defense also can make applications under Section 124 for appropriate directions on the investigators. So as I see it, there are problems, but the different new laws bring new problems. As I was just telling Justice Alvihar, money laundering cases where people's assets are seized, property is seized, we have a huge problem in trying to even get information. In many of the high courts, these files are kept in the custody of the registrar. The registrar will not tell you even the case number. So your client's property is seized. You have to go hunting all over. The registrar will not even tell you the case number for you to make an application in terms of the Money Laundering Act. And at every stage, it is your property which is seized. It is your houses which are seized. Some people have been put out of their houses, but the information is not being provided to enable them to. So a bona fide possessor, a person who has acquired property bona fide, has a huge task. It's a huge difficulty in trying to make an application to court under, and that if you look at the basic principles of fairness, if a person is being deprived of his property, surely he should be given adequate information why his property is being deprived. But that doesn't happen. So my fear is with all these new laws, whether it would get worse. And then what would happen? If you make the legal procedure too difficult, certain people will look for extra legal methods to get their properties released. It may be for them, it may be better to bribe some investigator and get the property released rather than going through a difficult court process. One last observation: travel bans. Many of you may not be aware that the new Anti-Corruption Act, the Bribery Commission can impose travel bans 3 months at a time. 3 months, it says the maximum of 3 months. There are people on whom travel bans have been imposed who have not even been informed that a travel ban has been imposed. Our courts of law impose travel bans on the request of investigators, but do not inform the person concerned that there is a travel ban in operation. That man goes to the airport, and at the airport, at immigration, he is told there is a travel ban, and he has to. So these are basic principles of fairness, which I think, as a legal profession, we must insist that that rules be made to ensure fairness.
Those observations, we can see that as criminal lawyers, particularly at the level of criminal investigations, what a proactive role we will have to play in the future. There are rights of citizens which are involved, proprietary rights, maybe restriction of their freedom, arrest and remand. At all those stages, I think it is the lawyers, the bar, who have to come forward in ensuring that their rights are protected. Now, from leading on from that point, our previous point about investigators and investigations, I would like to ask Mr. Mohan Veerakon, President's Counsel, knowing what a vigorous and passionate defense lawyer he is, the various problems we encounter, sir, in the area of bail, remand and bail. We have had the Bail Act now since 1997, before that under the Criminal Procedure Code. Still, even under the Bail Act, criminal lawyers face many problems. And with your experience in the original courts as well as the appellate courts, can you share some of your thoughts about the Bail Act, its application, and the problems that criminal practitioners encounter, and what your thoughts on those issues are?
Thank you, Asela. Good evening, ladies and gentlemen. It's a privilege to be in such eminent company. Justice Bunekali Vihari, Sali Piris PC, Sarajamana PC. Ladies and gentlemen, as you all are aware, these days, the most lucrative criminal practice is bail, as you all know. And we were discussing money laundering, proceeds of crime, all those things, and investigations. So when you come to the Bail Act of 1997, why was this act enacted? This act was enacted by then Minister Honorable G.L. Piris to release people on bail, because section 402 to 408 in the Criminal Procedure Code was was where the bail was mentioned. To do away with that and come up with a new bail act where the section 2 of the bail act says bail is the rule, non-granting of bail is the exception. But does it happen now? It does not happen that way. I have seen that it does not happen that way because before 1997, as you all are aware, there were two distinct offences, bailable and non-bailable offences. Bailable offences, if a accused was produced in court, he was granted bail as of a right. Non-bailable offences, accused was produced, and the maximum time that an accused could be remanded was 14 days. There were decided judgments on that. That Tunnea's case, and there was one DNAG case, I think there were two cases. So once this act was enacted, even for a simple offense like 314, 410, 433, a person could be remanded up to 1 year if the police so preferred. They could file action, they could report under section 14, where it specifically says that there are 4 grounds that a person can be remanded. That applies to both bailable and non-bailable offenses. Section 14, I'll quote that. It says, how bail could not be granted is that such person would, one is not appear to stand his inquiry or trial. Then 2 is interfere with the witness or the evidence against him or otherwise obstruct the course of justice. 3 is commit an offense while on bail. If he's inside, he can't commit an offense anyway. That's only a presumption. Then B is that the particular gravity of and public reaction to that alleged offense may give rise to public disquiet. So what happens in our magistrate courts mostly is that when police come and say investigations are not over, the learned magistrates, he just simply writes, investigations are not complete, bail not granted. But that is not a reason for bail not to be granted. Because he must specifically, police must file a report to say that this man is trying to interfere with the witnesses, or he is tampering with evidence, or he is trying to obstruct justice. So that never happens. Very rarely some magistrate writes that reason. So bail is refused, which is, I think, is illegal. Then, quoting from the Commissioner of Prisons very recently, where he, at Navalapitiya, he quoted that Sri Lanka has 36 prisons. And the prisons can accommodate 10,500 people. At the moment, our prisons are overcrowded. There are 36,000 people in our prisons. That's more than 3.5 times how the amount they can absorb. Out of that, 65% are for drug offenses, convicted people or people who are remanded. So when you take 65% of 36,000, it is 23,400 people are there for drug offenses. As you all know, the Bail Act is the prime law regarding bail. After the Constitution, section 13, the Bail Act is the law. Bail Act supersedes all the other acts regarding bail, except for those special laws. There are about 11 to 12 special laws where they say that exceptional circumstances or special circumstances are needed to grant bail. Again, they are also, you have to either go to appeal court in some instances or high court in some instances. You know, in the offenses in the penal code, 115, 191 and 296, you have to go to the high court to get bail. There are also the police investigation, like Mr. Sadi Piri said, investigate. If they do an investigation, a murder investigation, simple murder investigation, if you take, there's a altercation at a funeral house. A stabs B. B dies. There are witnesses. So what is there? No big deal because that has happened spontaneously. Sometimes they don't file an complaint in the magistrate court for 3, 4, 5, 6 months. And the tendency in the high courts is not to grant bail till the non-summary court is complete. Or at least the witnesses most important eyewitness have given evidence. But what can the eyewitness say? They give a statement when they see the offense committed, and that statement is read in court. No one can cross-examine, no judge can verify certain things. That's all. But if the police do not file a plaint in time, people can be remanded for 6-7 months till 1 year, because after 1 year, bail had to be granted under the new Bail Act. Before enactment of this Bail Act, a person in remand on a murder charge, if the plaint was not filed within 3 months, the learned magistrate had authority to give grant bail. I have taken bail in a case in 1996 or so, double murder case. 3 months plaint was not filed, magistrate court granted bail. That is there. Then talking about these drug cases, now 23,500 people are in remand in drug cases. The latest amendment to the Opium and Drug Act came in 2022, where jurisdiction for granting bail for above 10 grams pure heroin, that is net, was given to the appeal. So what happened? Appeal court, there are so many cases starting from 10.5 grams to 50 grams, 100 grams, 2 kilos, 5 kilos, 100 kilos also. So those people are incarcerated more or less forever, because the government analyst report, they can take 1 year to send the government analyst report to the magistrate. So till that government analyst report is sent, people about 10 grams has to be in remand. Earlier, the High Court had authority to grant bail for any amount of heroin. Their jurisdiction was, if it was found in Matale High Court had it, in Kandy High Court had, Galle High Court had it. Now, person from Jaffna, Batiklo, Matale, Anuradhapura, Mana, all have to come to Colombo to get bail from the appeal court. And most of the appeal court cases are laid by till the government analyst report comes. So people, so naturally, our remand prisons are full. So there are 23,500 people for drug offences in the magistrate court. So the simple amendments are needed. You give back the jurisdiction back to the high courts. Because if the high court can hear the case, sentence a man to death, why can't they grant bail? Simple argument. And we talk about overcrowding of prisons. And bail has to be granted. Bail has to be granted on Section 2, because this Bail Act supersedes everything. So even the exceptional circumstances, I have found out 10 reasons in the recent times where the appellate court has granted bail to people, especially in these heroin cases. 10 reasons. So cumulatively, they take 1, 2, 3 at 1 or 2, 3 together, and they say because of these reasons, we grant bail. One reason is not enough, but if there are 3 or 4 reasons together, cumulative, they say that there are exceptional circumstances, grant bail. But there's no uniformity in granting bail in our country. There are totally about 60 to 70 criminal high courts in our country. So below 10 grams also, certain courts grant bail in 6 weeks, sometimes 5 weeks, whether there are previous convictions or not. Certain courts grant bail in 3 months, sometimes 4 months, sometimes 6 months. Then sometimes after 6 months, cases are dismissed when there are 3 or 4 previous convictions. So what happens? Now these prisoners in this system, they are in these 36 prisons. They interact. So when Colombo person comes out in 6 weeks, and Kurunagal or some place, it takes 6 months for someone to come out, and some other jurisdiction, they take another, after 8 months, this case is dismissed. So where's justice there? Where do the people go? People curse the system. People curse the judiciary. People curse the council. And we are the people who get cursed most. Because they say, how? Yeah, Kurunagal, Kandy, I came out. Colombo, I came out in 6 weeks. But there, sir, you couldn't get him out. Get me out. So that we have a lot to answer in these matters. So I have covered some of the things that are important in bail. So I will come out with the other matters on next round. Thank you.
I think we have done first round of question and answers, and I want all the speakers for being very simple and also giving their responses in a very in very precise short answers. Thank you, sirs, for that. Let us go back to the His Lordship Justice Burne Kaluhare President's Council. So we had a bit of a general overview of what the anti-money laundering framework is and the offense of anti-money laundering. So you have been a prosecutor, you have been a justice of the Supreme Court, and if you put on the hat of a defense counsel also, you have the situations where third-party assets, innocent third-party assets, may also be subjected to anti-money laundering investigations and maybe even freezing orders. So most of us are in the private bar in this gathering. If we are called upon, say, in an investigation of that nature, and if our instructions are that we are a third party and our assets have nothing to do with this criminal offense, how do we navigate such a situation, and how do we handle a client who gives us that sort of representations?
Thank you, Asila, for the question. I think it connects up with what Mr. Salia Piris raised in the course of his explanation on the matters. I think in the issue that you raise, there are two parts to it. One is, could there be instances where innocent third party may find their assets being subject to anti-money laundering criminal investigation, right? The second one is, what is the role of the lawyer, right? So I will, because of the two parts, I will address in that sequence. Yes. Uh, when you look at Section 3 of the Prevention of Money Laundering Act, right? It it refers to instances where any person receives, possesses any property or proceeds of an unlawful activity. Technically, that person has committed a money laundering offense. Now, 2 weeks ago, I sold my Mercedes S-Class for 100 million to a sailor, right? And now there is a investigation, like Mr. Jayamana said, the corruption investigation against me, saying that I have delivered a judgment for after accepting money, and there's a corruption investigation. And then in the course of the investigation, they find that I have purchased this Mercedes S-Class with that money, and when the investigators come, the car is not with me. The car is with a sailor, right? So what will happen now? The criminal asset is with the third person. They will go and seize the asset. They will go and seize the asset. Why should they go and seize the asset? That is the other thing that we need to consider. Is it legitimate? Is it justified? Because now the property had been acquired by a third person. On one hand, it is justified. Seizure is justified. Why? Remember, when it comes to proceeds of crime, any transformation of those proceeds doesn't change the, the complexion of the taintness. For instance, I sell drugs, I get money, and the next day I invest that in stock exchange and I buy shares of a listed company, right? Still, that my shares are tainted. Why? Because I used illicit money or illegitimately obtained money to buy shares. The following week, I sell my shares and I buy bitcoins. Again, the bitcoins are tainted, right? In money laundering, it is called, right? Money laundering investigation is called follow the money trail, because people don't keep their assets in one form, right? It takes it takes different, it transforms into different types of assets. Still, the taintness of the asset doesn't get diminished. Even if I change it 100 times, still the last asset is considered as a tainted asset, right? So in money laundering investigation, but what they refer to is follow the money trail. That is the first mm, uh, instruction given to a money laundering investigator, right? It refers to a key investigation principle in combating money laundering and financial crimes, right? It involves tracking the movement of funds through various financial transactions to trace their origin, right? So I think I gave you the example. Now the problem is the vehicle is seized. So first part of the question is yes, you can find in money laundering investigations properties in the possession of innocent third parties get frozen or seized, right? Now assailant will say, look, I don't know how Justice Alvihari bought the vehicle. This is my legitimately earned income by defending innocent accused in court, right? Where they are falsely indicted by the Attorney General. I'm defending, and these are the fees I collected. With that only I bought the vehicle. Now then, the issue is he becomes a bona fide purchaser of property. Should he be deprived of that property is the issue, right? Now, if you are retained as a counsel, what should be your role in that situation, right? Unfortunately, because of the time constraints, I had a PowerPoint presentation prepared for this session to tell you what those provisions are, but I don't think we can go into it, right? If I can share it if you want to, I gave it to the organizers. The answer is very simple. All three legislations I referred to, carry provisions to safeguard rights of bona fide purchasers of tainted property, right? So, rule number one, if you are representing, you have to be fully conversant with those provisions. Those provisions are very clear. Because of the time constraint, I can't show them to you. But anyone who, if you read those enactments, these provisions are there. So first rule is be fully conversant with the applicable provisions to get relief for bona fide purchasers, right? Rule number two, right? Produce material before court that your client had no knowledge whatsoever that the property was tainted, right? In Asela's case, he will say, I like a fool, I trusted Justice Aluvari. I thought he's an honest man. I never thought he had bought this vehicle like that. I thought he had bought it with his good money. That is why I purchased it. So that shows he had no knowledge that this property was tainted. So you have to produce that evidence. Third one, right? Third one is you also have to show the money assailer paid is also clean money, right? That also is a requirement. So if you fulfill those requirements by applying the legislative provisions embodied in those three enactments, then you can get relief. Just to conclude, I will finish off with one line. Mr. Jayaman referred to the Anti-Corruption Act, and he said about the offense of corruption. Remember, the Anti-Corruption Act was fashioned based on United Nations Conventions Against Corruption, because we are a signatory to that convention, and we brought out this enactment. I think Mr. Jayaman is a surrogate father of that enactment, if I'm not mistaken. To in line with the Anti-Corruption Convention that Sri Lanka also signatory. Article 31 of that convention says all parties shall consistently ensure that the rights of bona fide parties should not be prejudiced when making legislation in relevance to freezing, seizure, and confiscation. So based on that, because we are duty bound, we have an international obligation in the international community to fashion our law in accordance with this convention, and that may be the reason why we have incorporated those safeguards into the Anti-Corruption Act. So I don't have time to go into the details, but I thought that's a very short answer I can give you. Thank you.
But clear explanation. So as you mentioned, as you were explaining to my little knowledge in the issue of normal confiscation at the forest ordinance and all that, the case of Manavadu came to my mind. The idea uh, of on one hand ownership of private property and whether a person has been involved in the commission of offense. I suppose that concept runs close to this.
Uh, yes, but I think it is better that we don't convolute Manavadu's case with this one for this reason. In relation to Manavadu's case, the question was by operation of law, irrespective of the knowledge, the person who gave the vehicle to transport illicit timber or illicit timber, whether by operation of law, it is strict liability thing, automatically it get confiscated or not, right? That was, I think, Manavadu's, if you look at Manavadu and now the development of the cases, that was a subtle issue that the court had to grapple with. Whether it's a strict liability thing by operation of law, irrespective of who gave the vehicle, if it had been used, whether he had the knowledge or not, if it had been used to transport illicit goods, whether it should be confiscated or not. So that is one aspect of the law. But when it comes to the forfeiture legal regime, Marcella, it is clearly spelt out how the court should approach that. Those provisions embody that. So under those provisions, the basic aspect that you have to establish is the purchaser had no knowledge, that this asset is illicit, illegitimate. Just to add to something, remember, money laundering is not committed by the person who commits the offense. There is what you call third party money laundering. Professional money launderers, as I said, right? They don't commit any criminal act. What they do is they help people who commit illegal activities and amass uh, assets to launder them. So they are also equally guilty of money laundering, though they have not committed the basic unlawful activity.
Our limited time schedule also. So, Mr. Sarachai, President's Council, I would like to ask the same question from you. Under the proceeds of crime law also, we might have a client who comes and says us, I have this property, this vehicle I have purchased. Now there is some investigation and the police are saying that this is a proceed of crime. What is going to happen to this? What can you do for me? Very simple explanations.
Thank you very much. For the benefit of the audience, in a simplest form, I would give the exact steps. Proceeds of crime investigations can be done by two agencies. One agency is the CIABOC, Bribery Commission. Other one is there's a special investigation unit set up by the IG. Why do these two agencies? If the original offense is related to bribery, corruption, or related offense, then the investigation would be conducted by the CIABOC. If it is any other offense, the investigation would be conducted by the special unit created by the IGP. Then, before you commence an investigation, they must be satisfied there is a reasonable suspicion that this is a proceed of crime. The property that they are eyeing is a proceed of crime. If they are not satisfied, there must be a fact-finding mission. Number two, after taking a preliminary decision, this is a proceed of crime, Before taking any other step, the investigator must give an opportunity to the person who controls, who is in possession of the property, and ask how you have come across this property. For example, if a person is in possession of a yacht or the Lamborghini or any other thing, you must first conduct discreet inquiries and satisfy yourself that this is a proceed of crime. Before doing anything, you must give a notice. Officially, you must give a notice and ask how you have come across. Then, if he is satisfied investigating officer, he can issue a restraining order or preservation order. If the property is somewhere in the bank or the Security Exchange Commission or the shares, the investigating officer in writing can tell, don't do anything with this property. You just keep it. On the other hand, if it is a movable property, he can seize. But he can't seize forever. He cannot issue a restraining order forever. Within 7 days of the restraining order, the investigator must go before the High Court and we must satisfy the High Court that there is a reasonable suspicion that this is a proceed of a crime. Then High Court might or might not. Maximum period is 6 months. It can be extended from 6 months each 4 times, and it can go to 2 years. In every situation, this what can you do? The innocent parties, they can go and claim. Then the other thing is, once the court issues an order under the procedures of crime, we give that name is freezing order. Freezing කියන්නේ මොකක්ද? ගල් ගහනවා. ඒ දීපල ගල් ගස්සවනවා. ඒකයි කියන්නේ freezing. So before the freezing order, an innocent party can come. Even after issuing the freezing order, the innocent party can come. Then what can the court do? Court can decide this whole thing is not a proceed of crime. Maybe part is a proceed of crime. So the court can identify and temporarily release this property to the person. Maybe court might ask to pay some security, to enter into some security, and court can do this. Then they can conduct investigation. On the other hand, if the proceed is a very valuable, and you have to always maintain. If a proceed is an airplane, a proceed is the many horses, any zoo, that is a proceed of crime. Do you expect them to bring those properties to the police station and keep it in the police station? No, you have to maintain those things. There has to be a property management authority. And once you decide this is a procedure of crime, you just freeze. That is not the end of the case. Still, it is not forfeited. All these investigations are part of the investigations. Once they satisfy this is really a proceed of crime, then only a separate application for prosecution of those properties will be filed in the High Court. Then only the property will be seized forever. Even after issuing the forfeiture order, so they can challenge these orders in the Court of Appeal and the Supreme Court. So challenge of the lawyers would be that very wide range of powers have been given to the investigators here. When you give such powers, it can be easily abused. It is up to the authorities. Not only the authorities, it is up to the members of the legal profession. Study these provisions. There is opportunity. There will be new legal culture. There will be new legal jurisprudence that can be developed. First, you must go and challenge this decision in the High Court. Failing which, you must go before the High Court, the Court of Appeal revision, and ultimately end up in the Supreme Court. Unless you go and challenge, get an interpretation, there won't be a development of the law. For the lawyers, with the introduction of this new law, procedure of crime law, and even the anti-corruption law, there will be a new avenue for your profession, your practice. I think, therefore, what I say is, enough power has been given to the investigators. In the meantime, there's a room, there are certain filters laid in that itself for a clever lawyer to find out those opportunities and make use of it. And today is only a basic and introductory discussion. Once we develop these things, you will master the subject, and there will be another line of your income as your profession. Thank you very much.
It's also, sir, the funds that they are going to pay to the lawyers are not frozen.
I must say one thing. Yes, if you are a party to this procedure of crime, even lawyers can be investigated. So you should not give instruction how as to how you should launder the money. You should not give instruction.
See that the government analyst report comes within 2-3 months. The government analyst during the COVID times came out with a notice to the Attorney General as well as the IGP, which said gross quantity of heroin always becomes the maximum amount will be 20%. So if you have 50 grams, it will be 10 grams or less. So by the time the government analysis report comes, as it is, I checked sometime back last year, 2024, when I checked, they said they were going through 2023 reports, the samples. So how long these people are incarcerated? And we are talking about overcrowding of prisons. So 23,400 people are in remand because they can't afford to get bail. Bail is not granted. Different courts grant bail different ways. So this, either the bail act is amended. Now regarding 296 charges. 296 charges, like I mentioned earlier, before 97, you could come out in 3 months if no plaintiff is right. If the police want to keep someone inside, someone can use influence, they will not file a plaint in the magistrate court. So that man will be there for 1 year. 1 year is the maximum that you can keep. So after 1 year, he can come out. What is the purpose? For a simple murder in a village where someone is hit on the head in a paddy field with a mammoth, or stabbed in a brawl in a funeral house. What is the purpose? There's very little premeditated murder in this country. When I started my practice in 1984 in Matale, I think the country had about 1,500 murders those days. Now, I don't think there are not more than 300 to 400 murders in the country. Very few murder cases. You all are, as criminal practitioners, you should be aware. Very few criminal cases, criminal murder cases especially. There are these gangland killings this way, that way. But our society has turned over. There are hardly any murder cases and no premeditated murder, planned murders like Kularatna, Kalu Albert, those cases are no more. Very rare. So I think we have to amend this act. Yeah, if it's justice for the people, it must be fair by all citizens of this country, wherever they live. Thank you.
And I also huge honor and privilege to have been able to moderate this session with such legal luminaries, His Lordship Justice Bune Kalugar, President's Counsel, Mr. Mohan Veerapon, President's Counsel, Mr. Sarat Chairman, President's Counsel, Mr. Sali Piris, President's Counsel. It has truly been a very interesting, very engaging session today. And I want to specially thank all the panelists for being very precise and very clear. And we have been able to all, we need a lot more time to meaningfully discuss these issues. We have somehow managed to finish this session in 1.5 hours. And also, I would like to thank each and every member of the audience, because I think as we discussed in this session, we can see what an important role each and every lawyer plays in every courthouse, magistrates, courts, upwards. If not for the members of the bar, all these laws will be meaningless, because our members go to court sometimes maybe with fees or without fees, as sir mentioned. So many times, I think lawyers, although there are various wrong impressions, I think lawyers work through a lot of difficulties, with various difficulties.
If you want to know more about process of crime, you can watch Wednesday. Last Wednesday's Mawat program of Sirasa at 10:30. More details are there about the process of crime law.
So with that, ladies and gentlemen, we will conclude this session and thank you very much. And thank you very much to the eminent panelists for having this very meaningful discussion. Thank you.